L.L.B studies. Subjects summaries. Contracts 1. Sections 1 to 75 of the Indian Contract Act 1872 in English language is the topic for discussion today. This topic I uploaded in two parts in Telugu language in the preceding two lectures. As a matter of fact, dear friends, I have decided to upload all the around 35 subjects prescribed for study of L.L.B and other judicial examinations. Despite untiring efforts, I would not able to complete maximum number of subjects but 18 subjects only. That is why I have decided to give summary of the each and every subject first and then topic wise. The reason for delay is earlier I uploaded lectures exclusively in English, thinking that no local language could be entertained for this L.L.B examination. So up to 145 lectures I uploaded only in English language only. Thereafter, at the request of my student friends of Telugu, I started uploading both Telugu and English. First day Telugu, and the same lecture is being uploaded in English language in a day or two. That's why, dear friends, never think that Rega Surya Rao is uploading the lectures in Telugu language only. So every lecture is there in English, but some lectures are there in Telugu language. From here onwards, every lecture is uploaded, will be uploaded first in Telugu, immediately will be uploaded in English language only. So this is the in every lecture, whether it is Telugu lecture or English lecture, I am speaking in English for 5 to 10 minutes, which are common for both English media and non-local Telugu state candidates. Don't think that this any information I am speaking other than subject, it is for your well-being only. As a senior citizen of around 69 years, I am. What are the troubles I faced in my life? You should not face in future as a human being, as a law student, as a distinguished scholar of law in future. So never make any adverse comments. Dear friends, today I will earlier I could not discuss elaborately this contracts 1. This subject contracts 1 containing section 1 to 75 was uploaded both in English and Telugu language, not only the summaries but also the chapter wise topics earlier. Now, in view of the students who admitted in L.L.B this year, as per for keeping in view their requirement, what to do, what not to do, what to opt, what not to opt, to enlighten them on various issues, I started delivering this subject wise. This today I am uploading this lecture in contracts 1 to some other subjects like torts and family law 1 were uploaded both in Telugu and English language. But however, I will upload the first 5 subjects of the first semester afresh only in one lecture. It may be 2 hours or 3 hours or even more than 3 hours. Please have patient hearing, because as a student I know up to 10th standard or maximum 12th standard, the students may be able to sit in classrooms continuously for so many hours. When once you become enlightened persons after attaining majority, you find it difficult to stick on to classrooms for hours together, dear friend. However, though you are not able to stick on to the classrooms and at the time of examinations, you would be ready to listen to the lecture 3 to 5 hours or even more than that. I have practical experience when I was a lecturer in Sir C.R.D. Law College, Elur, Andhra Pradesh. The students, before the examination, crowds of students, hundreds of students were to visit me for taking guidance 3 to 5 hours a day from 6 o'clock evening 6 o'clock to night 10 o'clock and beyond 10 o'clock, because they wanted to complete the whole subject in single day. So that is why, even though you find it very difficult to understand, listen to lecture for 3 hours, 2 to 3 hours, now you can comfortably listen to the lectures in the before the examination. At the same time, dear friends, for qualifying examination, you may neglect attending classes, listening to lectures, and reading more well. But when once you appear for competitive exams like MBBS entrance examination, postgraduate medical entrance examination, engineering national institutions entrance examination, judicial services examination, you must work like anything. You must strive hard. You are constrained to, you are forced to attend the classes more than 6 hours a day. 6 hours a day, because when once you join any coaching center of competitive examination, whether it is a competitive examination like civil service or judicial service examination, you will be given training, coaching classes for 6 months to 1 year, for which you will have to pay very lot of fee, and then you will be constrained to those in order to complete the all the syllabus of various subjects. The number of teachers will come and teach you. At the same time, after attending classes, you have to work day and night, not less than 10 hours to 18 hours also. Otherwise, you won't be able to get through the competitive exams like civil services or judicial services ADJ exam. Dear friend, please note that, don't hesitate to watch my lectures. I promise that I take very serious efforts. I work day and night. God provided me this opportunity to deliver these lectures, because I am constrained to give lengthy lectures, because if I split one lecture, it can be uploaded in 10 lectures also. If accordingly my lectures will come to thousands, so it will create lot of difficulty. So I also sincerely suggest you, dear friend, even as a newly appointed law teachers, are advised to watch my lectures first, summary, topic wise, and then take the book of his standard and choice and prepare for the examination. You can then you can readily accept whenever the head of the institution asks you to take up new subject. Otherwise, this is my personal experience I am telling, friends. Now let us come to the class. So here, in this two, I know, after after getting admitted into 3 years LLB course or 5 years LLB course, the institution may be unaided institution or private institution of without any infrastructure, or it may be prestigious law school of high wonderful infrastructure. Wherever you study, dear friend, whether it is the lowest center of legal education without having proper infrastructure and faculty, and it is the highly prestigious institution of legal studies having excellent infrastructure and faculty, the degree you get if you work hard and get your knowledgeable degree, even without knowledge, if you get degree from the institution of unique center of legal education, with that degree you can enroll as an advocate now in a lower subordinate court, lowest court to the highest court, like that is apex court in Supreme Court of India. If you work hard there, you come up like anything. So dear friend, so the Center of Legal Education primarily must be recognized by the Bar Council of India, the regulating authority of at New Delhi, and secondly, the institution to which university is affiliated, that university must be recognized by the UGC Grants Commission. If the institution is conferred autonomous status, then it should be recognized by the Bar Council of India, and then you get the degree. The degree is eligible to get qualified as an advocate. Again, will get you qualified to enroll as an advocate and start practice, dear friend. So I told you the importance and greatness of our legal education in previous classes, and make use of it and try to come up in future. Now, dear friends, now let us take up this contracts one subject, whole summary, and this subject, not only whole summary in English and Telugu, but also topic wise I uploaded long back. Even if the students, those students who could not prepare for the exam whole year, may also you can rely on this to get through the examination. Another thing is, I told you in the previous classes, as a good student, as a punctual student, what you have to do is, when you before attending the classes, if you give novel reading of all the 5 subjects under the semester, in some law schools the number of subjects may be more than one. In one law school, the legal language and legal writing also has been added apart from the 5 papers. So suppose you take the book of your choice, whether it is out of syllabus, your handbook, taking the advice of your teachers, and also taking the advice of your senior colleagues, and take the book of your choice suitable to your standard, and give novel reading of the book from first chapter to last chapter. And then if you attend the classes, you will be able to have interest and enthusiasm to listen to the lectures of the teachers. And secondly, even if you do not give novel reading of the subject before attending the classes, respective classes, if you give novel, you should give novel reading before going to appear for the examination. Whether 1 month before you prepare, or 10 days before you prepare, or 5 days before you start preparation, first of all you have to give novel reading of the particular subject from first chapter to last chapter, and then you have to pick out the most important questions in order of priority. First, suppose the most important question on top priority is there in 10th chapter, you can pick out that 10th chapter topic and start preparation. Thereafter 18th chapter, thereafter 5th chapter, thereafter 9th chapter, thereafter 2nd chapter, and so on. So that when once you give novel reading, you may you will be able to do it. If those students, if you watch my lecture summary, you can, if you then you give novel reading, you will be able to read that book very quickly. Whatever topic you can understand, you can understand very easily. If the time can be saved, dear friend. Now today I want to, this current subject contracts one is regulated, is codified. In our LLB course, there are in law there are innumerable number of subjects basing on their various enactments. Law of evidence is based on Indian Evidence Act earlier, now Bharatiya Nyaya, Bharatiya Shaksha Adhiniyam. In criminal law was regulated by Indian Penal Code 1860. Now it is repealed and substituted by this Bharatiya Nyaya Sanhita 2023, like that. So Indian Contract Act, like accordingly, there were about 19 enactments, 19 acts passed during Third Law Commission. So dear friend, you know, there are innumerable number of laws, legislation. What is legislation? What is law? What is enactment? What is statute? Is these almost all common, the almost all synonyms. But depending upon the situation, we will use what is legislation, the word legislation used in one time, enactment used in one's context, statute is used in one context, act is used in one context, and all these things. So this is a there is a slight differentiation. Suppose in that particular area law is not clear. That is why the government should pass legislation. At that time the word legislation is used. So for that purpose, to suppose law of torts is not codified today. In order to codify, what is codification? Codification means if any branch of law is systematically arranged in sections, subsections, clauses, subclauses, etc., we say that that law is codified. That law is codified. If law is not codified in the sense that particular branch of law has no act or enactment containing sections, subsections, clauses, etc. So the act or enactment, the act or code, some branches of law are called acts. Indian Evidence Act, Indian Contract Act, Transfer of Property Act, like that. Some legislations are titled as codes, Civil Procedure Code, Criminal Procedure Code, like that. Now recently the new enactments, Bharatiya Saksha Adhiniyam and Bharatiya Nyaya Sanhita, Bharatiya Nagarika Suraksha Sanhita, like that, those names were there. So as a whole, dear friends, our laws are some of our laws are codified. Very few of laws are not codified. Some laws are yet to be codified. Codified in the sense law of torts and law of Indian Penal Code today, Bharatiya Nyaya Sanhita, for example. Bharatiya Nyaya Sanhita, for example. Here, in Indian Penal Code, defamation is there. Defamation, one way tort and another way crime. One way tort in the sense civil liability, other way crime in the sense criminal liability. So when you speak when you speak defamation in law of tort, there is no any section number. Defamation, civil liability, some compensation is to be payable to the aggrieved party. If you speak this defamation as a crime in criminal law, the section 499 defines defamation, and section 500 prescribes punishment for defamation. What is the concerned section in Bharatiya Nyaya Sanhita? We have to discuss. So that is why in British, that is why in dear friends, we study very limited number of subjects. The object of telling all these things is we are going to study around 30 subjects in LLB. In LLM, there may be very few, less than around 5 to 6 subjects in LLM, maximum 10 subjects. And the same subjects of LLB may be, some of them may be same subjects to be repeated in LLB or LLM also. Whatever the students study the same, they will repeat in LLM also. And for PhD, particular area, particular subject, particular area will be taken up for completing the research project. So that is why, dear friends, during British period, thousands of legislations were passed, and what they in one survey, it revealed that there are more than 6,000 laws in India. How our central legislative body is Parliament of India. Our central legislature, Parliament of India, passed around more than 1,000. 1,300 one report tells, 937 one report tells, 897 one report tells. Anyway, around 1,000 legislations were passed by the Parliament of India. So in there are nearly 264 bills are pending. When once these bills are presented in Lok Sabha, Rajya Sabha, and then sent to President of India, followed by gazetted notification, they also will become law. Like that, they are the passing of legislation is in progress. Then we say that some bills are pending. The total number of bills are 264, including Nari Shakti Yojana bill, and providing a 33% reservation to women in elections, in general elections. And another bill is Jammu and Kashmir Reorganization Act also is there recently, because originally when after the abolition of Article 370, Jammu and some problems took place. In order to overshadow those problems, again the Jammu and Kashmir Reorganization Act also has been proposed to that effect. Bill is presented there, and similarly there are when once when in the beginning in the early days of Constitution, right to property was abolished as as a constitutional right, as a fundamental right. It was treated as a legal right, because if any property, public property is required to be taken for public purpose, for writing railway track or for widening roads or construction of new road, then in that process some lands, agriculture lands or private lands of the public are to be acquired. Then those owners of those lands should not should not approach the court for the saying that their fundamental right is affected. So that is the reason why to require public lands and public properties for private lands and private properties for public purpose, these right to property was abolished. Subsequently, so many agrarian reforms were passed, agrarian reforms to ensure the social welfare state and to provide equitable distribution of wealth and all these things. What is that agrarian law? What is its importance? I will let you know as and when times. So like that, for that purpose, in order after the abolition of this, ninth schedule was added to the Constitution of India. Under ninth schedule, there are 285 legislations are there, agrarian laws. So that is why thousands of legislations are there. These during British period, around 1,000 laws were passed by the Parliament. These 264 laws are pending in Parliament. 85 laws are agrarian laws, and innumerable number of legislations are being passed by the respective state legislature by under the principle of the delegation of legislation, delegated legislative power, and the parliament by delegated power transferred the power of lawmaking to the state, to the executive, that is governor of various states, so as to enable the legislators of the respective states to pass legislation. In view of this, what I'd like to tell you, dear friend, there are many number of laws. What we are going to study are very limited. I suggest you concentrate at least to learn these minimum number of subjects. Get yourself acquainted with various laws, what you are going to prosecute, what you are going to learn during while prosecuting your legal studies, and get yourself acquainted with various principles of law. Go to court as a full-fledged lawyer with full-fledged. For all these only I have given big introduction. Don't misunderstand this. Don't make adverse comment that Raga Surya Rao is making teaching unnecessary aspect. These are the first most important thing. If you there are when once there are the laws in thousand, when once you don't study the laws in tense, we will not be able to justify the supreme status conferred on the judiciary as a responsible lawyer tomorrow and more responsible judge day after tomorrow. For these few lines, I wish to put an end and start taking up this subject. This subject, contracts 1. The law relating to contracts is governed by the Indian Contract Act. So, the civil procedure is governed by the Code of Civil Procedure. Criminal procedure is governed by the Criminal Procedure Code, now Bharatiya Nagarika Suraksha Sanhita. Like that, the law of evidence is governed by Indian Evidence Act. Like that, the principles relating to contracts, the law relating to contract is governed by the Indian Contract Act 1872. This is one of the 19 enactments passed during Third Law Commission. With this, there were other legislations, namely Indian Evidence Act 1872, Transfer of Property Act 1882, Easements Act 1880. So other enactments also were passed during that period. That is during British period. You know, dear friends, Britishers entered Indian soil in 1600 AD and ruled over India up to 1950. That is, during the period of 350 years, Britishers ruled over in India. and their laws. We are addicted to English laws. We are habituated to the titles of the English laws, English titles of the various laws. Among the 19, the Contract Act is 1872. It came into force on 1st September 1872. This enactment is successfully being applied and interpreted in various courts for more than 250 years. Now, dear friends, this what is this contract? Contract means for every issue from the by the time we get up from bed to till the time we go to bed, we come across various transactions. We need so many things, food, clothing, shelter, and all. For that purpose, we meet somebody, we associate with somebody, we contact with somebody. That contact is put in so many words, it becomes contract. So the word contract is derived from the Latin word contractum, which means drawn together. When two individuals, two parties, two persons come together for some for purpose of some lawful activity, legal activity, then that is called, that contact becomes contract. So contract. There, by exchanging of views, an agreement is constituted. If that agreement is valid and enforceable, that agreement becomes a contract. So contract means valid agreement. So there is no need to tell separately that valid contract. Valid contract. Agreement may be lawful or unlawful. If the agreement is lawful, it is enforceable. That agreement becomes a contract. If the agreement is not enforceable, it is not contract. So, according to Section 2H of Indian Contract Act, an agreement enforceable by law is a contract. Enforceable by law means getting, if one of the two parties does not attend the contract, does not observe the contract, or if one of the parties fail to perform the contract, the other party is called aggrieved party. Then he can go to court and get the other party perform the work or get the work completed. Suppose A offers his house, A wants to sell his house for 50 lakhs, B wants to sell it. If so B gave advance of 20 lakhs, and if B doesn't pay 30 lakhs and take back, A can file a case. Then there is a breach of contract on the part of B, and A can file a case against B and get the work done by, that is called performance of the contract. So the that is called performance of the contract. So this is valid contract, valid agreement. It can be enforced. So court will ask the B to pay 30 lakhs and take the house. Suppose today A agreed to give house for 50 lakhs, received 20 lakhs advance, and subsequently rates are increased in that area. Some companies came and the 50 lakh house became 1 crore. Then A wants to cancel the contract or repudiate the contract. Then B can insist the A accepting 30 lakhs, remaining 30. If A doesn't agree for that, then B can file a case against A and get the contract done by court of law. The getting the work done through the court of law is what is called specific performance or enforceability. That is why an agreement enforceable by law is contract under Section 2(6) of the Indian Contract Act. This is what is called Contract Act. So dear friends, this Contract Act is broadly split into two parts. First part containing sections, six chapters containing sections 1 to 75, lay down various provisions relating to various general principles. Then the second part, chapter 7 to 11, 5 chapters containing various provisions deal with specific contracts. What is the general contract? What are the general principles? What are the specific contract? So all the general principles, a contract if any contract which is studied in specifically, that contract basically contains the principles. Subsequently, it will have its special features or specific features basing on the all specific contracts basically primarily contain the basic principles of the contract. Basic offer, acceptance, consideration, legality, free consent, legality, object, like that. And in addition to this, every contract, whether it is the contract of indemnity, guarantee, bailment, pledge, pawn, whatsoever may be agency, basically the contract contains the that particular contract contains the principles of contract. Subsequently, it will contain some more special features. Depending upon the special feature, that particular specific contract is identified as indemnity, it is identified as guarantee, it is identified as a partnership, and so on. So, dear friend, like that, I give you some small common example, like spoon feeding. For example, human being is there. Human being means man or woman. Human being. Every human being will have normally some organs: eyes, nose, mouth, ears, hands, legs, like that. So these are, assume that these are the principle. Every human being, man or woman or misgender or Hindu, Muslim, Christian, Jews, Jain, whoever may be, whether European or South Africa, Latin American, North American, Latin American, Australian, or Indian, Chinese, Pakistani, like that, Tamilian, Andhra, Telangana, Malaya, Keralian, like this, whatever may be the thing. So these are first, the every human being, man, woman, or misgender, will have commonly these certain things called nose, ears, eye, like that. They are hands, legs, they are common like principles. So man means man will have some special features, woman will have some specific features, misgender will have some peculiar features, like that, like that only. Hindu, Muslim, Christian. Hindu worship Lord Rama, Allah, Venkateswara, like that. Muslim worships Allah, Christian worships Jesus, like this, like this. So these are the specific features. So that is why the Indian Contract Act contains 200, the whole act contains 266 sections, divided into 11 chapters. 266 sections, divided into 11 chapters. First chapter to sixth chapter contain, these six chapters contain 75 sections. 75 sections. All the 75 sections provide various principles of law, like offer, acceptance, consideration, capacity, free consent, legality of the object, like that. 75 and 68 to 72, the principles relating to performance, principles relating to discharge, and contracts which resemble the agreement which resemble legal agreement. So like this. See, these are the part 1 section. This Indian Contract Act 1872, which came into force on 1st September 1872, consists of 266 sections, divided into 11 chapters. Chapter 1 to 6 contain 75 sections, deal with principles, namely offer, acceptance, consideration, etc. Whereas section 76 to 266, all the remaining sections under chapter 7 to 11, 5 chapters, lay down various provisions relating to specific contract, various provisions relating to specific contracts. Now, chapter 1 to 75 deal with general principles. 1 to 75 under chapter 1 to 5 deal with 1 to 6 deal with this chapter chapter 1 to 6 containing 75 sections deal with principles like offer, acceptance, consideration, etc. Section 76 to 123 earlier, section 76 to 123 of the Indian Contract Act laid down various provisions relating to transfer of movable property from one living person to another living person. Transfer of movable property from one living person to another living person. What is the movable property? TV, fridge, etc. like that, movable property. From living man to another living man. So, if any dispute was there, sections 76 to 123 dealt with that dispute. The problems were decided according to Contract Act from 76 to 123 earlier. However, in this area, the litigation from 1872 to 1933, the Contract Act, these section 76 to 123 dealt with regulation of dispute under transfer of movable property. But in that year, these sections 76 to 123, all the sections were repealed, deleted, abolished, and in that place some new enactment was passed. That enactment is Sale of Goods Act, Sale of Goods Act 1930. This Sale of Goods Act 1930 was shown as chapter 7 under the Indian Contract Act. So thereafter, from 124 to 147, these sections lay down various provisions relating to the contract of indemnity and guarantee. Contract of indemnity and guarantee. Contract of indemnity means in that there are two parties. What two party? So it is a contract. Indemnity means the contract is entered into two parties. If one party promises other party to compensate if he comes across loss. For example, car insurance we are doing. If anything go, every year we pay car insurance. If anything goes wrong to car, the insurance company will pay. If nothing happens, that premium will go to insurance company as profit. Similarly, we are taking medical insurance. Suppose for 1 year we pay medical insurance. If we are hospitalized during that 1 year, the insurance company will pay the medical expenses. If a person is healthy and no ailment, that premium goes to insurance company as profit. So that type of contracts are called contracts of indemnity. Now, other type of contract is contract of guarantee. In contract of guarantee, there are three parties. Three parties. One party takes loan from advance from other party. The person who received the loan or advance fails to pay, some other should come to the scene and should pay. That type of contract is called contract of guarantee. Suppose you go to bank, ask the bank to get a loan of 10 lakhs. The banker is ready to give you 10 lakh loan. At the same time, the bank will ask you to bring guarantor. Guarantor. If the guarantor may be one guarantor or two guarantors or three guarantors. Suppose a guarantor, some rich man or wealthy man is there, then in case the banker, the debtor dies, the banker can recover the money from the guarantor. Guarantor. So, what is guarantor? This guarantor is also called as surety. What is contract of indemnity? What is the contract of guarantee? Who is the principal debtor? Who is the creditor? Who is the surety or guarantor? All these topics we studied in this. I gave elaborate lectures in this in previous already uploaded on this. And next one is next chapter is six 1 to 6. Seventh chapter is Sale of Goods Act. Eighth chapter is Contract of Indemnity Guarantee. Ninth chapter ninth chapter, section 148 to 181. Indemnity guarantee, section 124 to 147. Then after that, the next chapter is ninth chapter is contract of bailment and pledge. Contract of for section 148 to 181 of Indian Contract Act. All these sections deal with the contract of bailment and pledge. Bailment means delivery of goods from one person to another person for some purpose. After the purpose is over, the transferee or bailee should return the property. Suppose the person who transfers the property is called bailor, to whom the property is called bailee. The proper subject matter is called, the contract is called bailment. Suppose you give your car for servicing or repair to garage owner or Maruti showroom, you are called bailor. The Maruti showroom is called bailee. After the purpose is over, servicing is over, the car should be returned to you. That contract is called bailment. Contract is called bailment. Next, second one is pledge. Pledge means tendering or surrendering some property for some loan. For some loan. That is what is called pledge. So the pledge, that some property is given to banker as a security, some pledging something and taking loan. That is called a pledge. So if the pledge sometimes it may be delivered, sometimes may not be delivered. Then if it is delivered, it is called pawn. It is called a pawn. For example, you give your gold to bank. We give some property to bank and take loan. Sometimes we pledge our gold to bank for loan. In that time, sometimes we give some security. Sometimes we surrender the property. Sometimes we do not surrender the property. In this way, some other issues like hypothecation and hire purchase, all these aspects will come. All these things I explained in detail in this chapter, the contract of bailment and pledge, dear friend. It was uploaded long back in English language only. Telugu I did not do it. Now next chapter is 10th chapter. That 10th chapter, section 182 to 238, 182 to 338. All these sections lay down various provisions relating to contract of agency. Dear friend, there are so many persons of high status, they do not do their work on their own. They engage some agents, they engage some delegates, they delegate their work to someone, they entrust their work, they delegate their work to somebody to attend the work on their behalf. Then that person is called principal. The servant is called agent. The relation between the principal and agent is called contract of agency. What is contract of agency? What are the various kinds of agency? What is the dissolution or termination of agency? All these aspects I explained in detail in English media long back, dear friends. So last one is section 239 to 266. All these sections earlier dealt with the law of partnership. Dear friends, partnership, when two or more persons carry on business. In one man carries on business, it is called sole trading concern. If 2 to 10 persons for banking business, banking purpose carry on business, it is banking business. If 2 to 20, not more exceeding 20, carry on business for any other purpose, that is called partnership business. In that partnership, there may be minimum 2 persons, maximum 10 partners in banking business, maximum 20 partners in the non-banking business. So in that banking, all partners are having equal responsibility of assets and liabilities. The act done by one partner is an act done by other partner also. When there is any dispute takes place with reference to the sharing of liability or making of payment of the partners is concerned, if that dispute is was to be resolved, such disputes were resolved by the Indian Contract Act from 239 to 266 earlier. But in 1932, all these sections were deleted, repealed, and in their place, new enactment was passed. That act is called Indian Partnership Act 1932. But so far as the seventh chapter to 11th chapter, section 76 to 2066, I am not supposed to teach you in this particular lecture, but for information purpose only I have taken. And however, dear friend, here these what is the summary of all these things I tell you? It may be 2 hours or 3 hours. Please have a patient hearing, and you may watch half an hour like that, and you write working notes and listen it with that knowledge, with that side heading. You will be able to go through the exam. Such of those students who cannot concentrate more in classroom teaching, and who cannot read throughout the year, such students may follow it. If students of prestigious institution watch my lecture first, attend classes, they will be able to receive the advanced knowledge imparted by the reputed and eminent teachers of the national law schools and prestigious law schools. And you may treat my service as a basis and promote your knowledge with the intellectual teachings of your intellectual giants of various national law schools and prestigious institutions of legal studies, dear friends. Now coming to the point here. So now we have to discuss section 1 to 75 under chapter 1 to 66 of the Indian Contract Act. Is contract one. Now, dear friend, when you in your handbook, some books are there, subject syllabus is there, books are there. So in your you will be given calendar of the college after your admission. That calendar contains syllabus of various subjects from first semester to last semester. At the end of every syllabus, there will be some books are prescribed like H.M. Shirvai, D.D. Bashu, commentaries, Koka Subbarao, Winfield, Solomon, Ramaswamy Iyer, like that some books of highly reputed authors may be given in the at the end of the syllabus. Dear friends, according to my knowledge, I have gone through the syllabus of various universities, but there is a little bit confusion in framing the syllabus. In that syllabus, for example, starts in the beginning they go to negligence or strict liability and no fault liability like that. So, when the no doubt liability are to be taught after 10th chapter or 11th chapter like this. So, such jumbling will be there. So, those draftmen of the syllabus, they are very intelligent. They think that the student also will have that much knowledge and can understand. They write the syllabus in that level. But however, the newly innocent entrants may not be able to follow that. So, what you have to do is the books available in the market are of two categories. One type of book is chapter wise. One book is authored in chapter wise. One book is authored in section wise. For example, Indian Contract Act you take. Some books, chapter 1, contract meaning a contract. Nam contracts to chapter 2, offer and acceptance. Chapter 3, consideration. Chapter 4, free consent. Next chapter, capacity. Next chapter, legality of object. Next chapter, performance of contract. Next chapter, discharge of contract. Next chapter, quasi contract. Last chapter, remedies. This is the chapter wise content. Accordingly, for examination point of view, you have to read chapter wise only. The question is asked on offer acceptance, the question is asked on capacity, the question is asked on legality of object like this. but in section wise the classes may not be asked. Some cases only section may be asked, that is different thing. Whereas the chapter wise is a book you purchase for textbook for examination purpose and prepare for that. In section wise textbook, the sections for in bench and bar, any case the principal issue involved in any particular case is particular section. So when once a particular section is involved in any particular case, the lawyer or judge must have depth of knowledge in that particular area. So that is why the big writers, great authors, they write the book in section wise. In section wise, they write about the section, some bare act, whatever is there in bare act, it is reproduced in the textbook. And under the bare act, what is that bare act? What is that section tells? How many clauses are there? How many provisos are there? What are the explanations are there? What are illustrations are there? All these things the author will have to explain that particular section only. What are the relevant cases are there in that particular section? By giving footnote, one author may give 5 cases, 10 cases, 20 cases, even 50 cases for particular one chapter. Either any lawyer or judge, while dealing with particular case, will go to that particular section, have a glance on these sections relevant section content, and relevant crucial definitions, if any crucial definition is given to that particular concept being studied under that particular section, in that section, and it is the judge or lawyer will have to go through and what are the relevant section. If any relevant section is connected to his particular case, lawyer or judge, then they will see the citation of that case and will go to the All India Reporter, Criminal Law Journal, very big books which you find in a lawyer's chamber, and they will pick out that book, go through that. It may be available in net also. It is very difficult to see all the number of pages in cell phone or computer. That is, a book is incompatible. In spite of all whatever is there in all books available in internet, it is not possible to refer each and everything in screen, on the screen of cell phone or that is why invariably they have to see the book. If he is a leading lawyer, he will give that work to junior advocate and see the relevant case, see the particular case on basing on citation, and that junior lawyer will go through that and mark it with a yellow marker and put flag and place it before the lawyer and see the few words. By virtue of his experience and knowledge, he will present the points before the judge and try to convince the judge to decide the case in his favor, is what is normally done. Even if the student is the student level, goes through those section wise and everything, go in depth, you can highly appreciate the student, that the students are started possessing knowledge in level. In some prestigious schools of law, they are conducting seminars, national seminars, state level seminars, interaction, group discussion, cases hearing, all these things they are doing. And normally, the students prosecuting legal education in the prestigious institutes of legal studies, they studied in global schools and international schools. They have very good command over the language. They will be able to understand the section wise and all. Our law students also who studied in English media and everything, they too can follow. But for time being, the section wise depth knowledge and depth study is good for procuring more and more knowledge. It is not necessary for writing examination. If any student goes through a particular section, referring number of sections, number of cases, and wish to present that material, he won't be able to answer all the questions. That is why, dear friends, you confine to your survey, confine to your work relevant to the examination, and whatever book you read, it may be hundreds of pages or thousands of pages. While preparing the book, you have to write the running notes of 50 to 100 pages, and you have to give full side headings. You have to underline the side heading, you have to underline the cases, you have to underline the section number, you have to by heart the cases, the section number, and all crucial points, and you present it as it is and write the matter out of your own language by virtue of knowledge. then only your answer will be attracted. It will answer will attract the examiner to award a good number of marks. This is what this that is why when we were studying LLM, our professor was giving so many references of books. We were going to library whole day. We would able to get some 3 4 5 pages only referring all those books. All these books you see Shirvai, you see D.D. Basu, you see Kaukaro comment, you see like this. They were telling. For that, we were sitting in the library day and night. We were collecting very limited number of pages, and whole day we were sitting. We brought only 5 to 10 pages. So that is there. So like that work, collecting good information from various books. I prepared notes of 30 to 40 pages. Some subjects. Legal theory 19 pages I gave undertaking. You dear friend, you believe or not, by God I tell you, I had to struggle a lot, prosecute hard labor, making untiring efforts to prepare the show the subject in 20 30 to 40 pages of full scap 1.5 typing, and those study material I circulated in Eluru and entire state. Whatever discount was given to me by Xerox man, it was given to the bookshops in various bookshops in the state. And ultimately, when once I approached the Asia Lahore to sell my notes of 30 to 40 pages on 24 subjects, that man wanted a proper, this Miss Sunil Gogia, proprietor of that prestigious organization, uh, wanted to publish my books. I felt very happy. Such a big leading publisher wanted to publish. Then I gave him for very small intellectual labor charges, very meager charges, of which I had to forego income tax also. That is the reason that very limited meager money I gave him, and ultimately with his cooperation, he circulated the books all over India, made me popular. Whatever I got, but I became popular all over the country because my student friends, my student, one great actor, Akini Nageswar Rao ji of Telugu, greatest, one of the two greatest actors, Akini Nageswar Rao NTR. He used to prescribe his audience as the Pratchaka Devullu, but according to him, he doesn't have any god of his own. His audience who watch his movies are his god or his god. Similarly, I sincerely acknowledge my student friends as my god and goddesses, because you are responsible for me, for my present day, and that is the reason why I sincerely honestly promise you to spend a whole life, remaining whole life, to serve you absolutely on service motto. What a little is generated, income is generated, I don't take even 1 rupee. I pay many times of that contribution, YouTube amount generated, I give to charity for temples in poor condition or poor people only, dear friends. I never eat even 1 rupee. If I eat 1 rupee from this YouTube income of around $100, which I get in 6 months to 8 months, that is no way nothing for me. My charity is of multiples of what I receive. So this is the reason, dear friends. So you please, if you have unlimited data, you watch my TV, watch. If you have Wi-Fi, you watch it completely on internet. If you have very limited data, you, some children who don't have more money may take very limited data. They may download it and share it to all of your friends. Watch it. If you find that while the lecture is lengthy, you watch it half an hour like that, and serve your purpose. Dearly, particular for Telugu student, I sincerely tell you, dear friend, it is a wonderful, great opportunity to you. No teacher so far in any channel uploaded these lectures, lengthy lectures, whole lectures and chapter wise, making such a lengthy preparation both in Telugu language and English language. It is a good opportunity for you, particularly for the students of Telangana and Andhra Pradesh. But I am very unfortunate that I cannot speak Hindi fluently. Otherwise, I would have uploaded lectures in Hindi language also. Hindi language also. Hmm? Hindi language also. Now, I am extremely grateful to my student friend for reaching my channel to 19,500 nearly. In one a day or two, it will become 19,500. In case I would have uploaded my lectures in Hindi also, the number of subscribers would reach to 20 lakhs, would have been reached to 20 lakhs. Though directly around 19,500, but indirectly, some I am given to understand from reliable sources, some lakhs of students are following my lecture. Even in our National Law School students also, prestigious law school students also are following, is what I tell you. In few after few level I will uploading, I will tell you some important facts in my life. Then I will tell you what is the type of honors I received. I will tell you so as to inspire you, inspire you to watch my lectures. And now, dear friend, so this is a bailment and pledge agency. Section 182 to 138 is agency. Now section 2 section 2 that 181 to 238 181 148 to 181 bailment and pledge, 182 to 238 contract of agency, termination of fees, all these things. And last chapter, 11th chapter contained containing section 239 to 266 dealt with law of partnership. That partnership, these all the sections were abolished, and in that place section 73 schedule 2, schedule 2 they abolished schedule 2, section 73 schedule 2, these sections were abolished, and new act, Indian Partnership Act 1872 1832 was passed. 1832 Sale of Goods Act 1930, Partnership Act 1932. Within a gap of 2 years, these two acts were passed. Now coming to the friends, this is with reference to chapter wise discussion. So schedules, any act is passed. Some first preliminary one to two or 1 to 3 sections will be there. From third section or section 3 or section 4, chapters will start. After all the chapters are started, then schedule may be there. Schedule in the sense, for example, I tell you, your first entrance, I want to tell you what is the enactment body, what is the body of the enactment. In any act body, in body of any act or enactment, first 2 sections or 3 sections will be preliminary aspect, preliminary aspects, title, extent, application. Second one is savings may come. If savings is, what are the savings? What is savings? I explain in detail. And the third one is section, interpretation clause. In some acts, section 2 is interpretation clause. In some acts, section 3 is interpretation clause. For section Indian Contract Act, section 2 is interpretation clause. In section 2, so many definitions are there. Offer, acceptance, 2A, 2B, consideration, 2D, like that. The interpretation clauses will come. And for in some enactments, Transfer of Property Act, Indian Evidence Act, etc., section 3 will be interpretation clause. Earlier IPC section 2, CRPC section 2 is interpretation clause. From third section on section 3 onwards, chapters will start. Some chapters, after the last chapter, some savings may be there or some schedules may be there. What do you mean by schedule? For example, earlier CRPC 2 schedules were there. One schedule contained what is the model of, what are the bailable offences, tables are there. What are the bailable offences, non-bailable offences, cognizable offences, non-cognizable offences, summons cases, warrant cases. That is one schedule. Like that. What is the pro forma of FIR? What is the pro forma of charge sheet? What is the pro forma of affidavit? All these are there in second schedule. Like that, in Indian constitution also, so many schedules are there. This schedule contains states and union territory. One schedule contains what are the languages recognized in India. One schedule contains what are the like that section 9. What are the various law agrarian laws passed by various states in India. Like that. In schedules also, I explained in detail in constitutional law. When once I repeat once I'm going to take up this constitutional law, I will tell you what are the various schedules, what they deal with. That topic also I will tell you. Schedules. So this Contract Act also was having that is schedule mean section 73 schedule 2. It was repealed and it's the Indian Partnership Act was passed. So now coming to the this Contract Act is chapter wise, and this Contract Act is section wise also. If section wise is how this section, so we have to in 266 sections are categorized under 11 chapters. So, according to Act, 11 chapters are there. What chapter 1 tells you, what chapter 2 tells you, what chapter up to 11 tells you, I will tell you. So that you will have idea whether to read the book containing chapter wise is correct, whether to read the book containing section wise is comfortable, you will be able to understand. In section wise book, Contract Act 1872 contains 266 sections. These 266 sections have been divided into 11 chapters. Under 11 chapter, 11 chapter. Section 1 to 2, section 1 to 2 dealt with title, extent, application. This is the title. They mean it is Indian Contract Act. It applies to the whole of India except the state of Jammu and Kashmir. After recently abolition of 370, it extends to whole of India including the state of Jammu and Kashmir. Section 2 interpretation. It contains so many definitions. Offer 2A, exceptions 2D, consideration offer 2A, acceptance 2B, consideration 2D, like that. Various definitions are there. And now chapter 1 deals with communication of acceptance and revocation of proposals. Chapter 1 according to section wise classification book, chapter 1 contains section 3 to 9. These sections, these 7 sections deal with communication of acceptance and revocation of proposals. What is communication, acceptance and revocation of proposals? It very first chapter goes to middle. We have overtaken what is contract, meaning, definition, kind, so directly it has gone. Communication of acceptance means revocation of proposals. What is communication of acceptance and revocation of proposals? Suppose I have house worth of 50 lakhs. I want to sell my house worth 50 lakhs to my friend. My friend X agreed to purchase. So when I told my friend to purchase my house for 50 lakhs, I am called offerer, I am called proposer or promiser. My house is proposed to my friend. My friend is called promisee or proposee or offeree. So, if my friend is ready to purchase my house, he should give me information. Yes, I would like to purchase your house. I will send you an advance within so and so time. So, the reply of my friend to purchase my house is called communication of acceptance. So, when a house is offered for sale to B, if A offers his house to sale to B, A is called offerer, B is called offeree. A is called promisor, B is called promisee. A is called proposer and B is called proposee. So when the offeree or promisee should express his willingness to in writing or written to offerer, then it is called communication of acceptance. అలాగే if if I don't give if I don't give, when my house friend, when I offered my house to sale of 50 lakhs to my friend, he should give information that he should communicate that he is willing to purchase my house. Then I should keep the house pending. I should not sell it to anybody. But my friend has not given any information. He has not given any communication. So he has not communication of acceptance is not there to me, then I can purchase it to another man for 60 lakhs. After selling my house for 60 lakhs, my friend may come and dispute. Why you have sold it for 60 lakhs? I told you I wanted to purchase it for 6 lakhs. But you did not give me any information. You did not communicate me. That is why. So, non-communication of acceptance renders the contract valid, can renders the contract invalid. The offerer can contract it with another person. Next, second one is revocation of proposal. Revocation of proposal, revocation of offer, revocation of offer, all are same. Revocation of proposal, withdrawal, going back, taking back. So, I have 50 lakh house. I offered this house for sale to my friend for 50 lakhs, but he has not accepted readily. He may take some 10 days or 20 days. After that, before he accepted it, I got better business. Somebody came to purchase my house for 60 lakhs. Then I gave it. Then I can revoke my offer. I remained my house offer. I remained my house for sale to you for 1 week or 10 days, but there is no any information from you. But before receiving the acceptance, he can revoke, the proposer can revoke it. Suppose he gave me acceptance, I agreed for it. Then after entering into agreement, if somebody came and if I give that house for 60 lakh, it is breach of contract. He can file a case against me. So this is what is called revocation of proposals. So according to section wise classification textbook, first chapter, chapter 3 to 9 deals with communication of acceptance and revocation of proposal. That is first. Next thing is second chapter. Second chapter is section 10 to 30. This deals with voidable of this section chapter 2 deals with contracts. Section of contracts or contracts. Section 10 to 30. Section 10 to 30 voidable contracts and void agreements. Voidable contracts and void agreements. Voidable contracts and void agreements. So anyway, the contract is emerged from agreement. Contract is emerged from agreement. What is agreement? When two persons or two parties come together, express their willingness to do some transaction, to enter into take up some transaction, to do some activity or service, that is called agreement. When two parties come together, agree to do an act or abstinence, to do an act, omission or an abstinence for some lawful consideration. When two parties come together to do something, it is agreement. The two parties are drawn together to do some legitimate act, positive act, legal act. It is called agreement. So agreement. Here, if the agreement is a valid agreement, if the agreement contains all conditions of section 10, that agreement is valid and enforceable according to section 2 here. When two parties together, when one party makes valid offer under section 2a, other party gives acceptance and valid acceptance of section 2b. When section 2a valid offer, when section 2b valid acceptance, agreement and acceptance, valid agreement and valid offer and valid acceptance come together, it forms agreement. It forms an agreement. If that agreement contains conditions of contract under section 10, so the contract, the agreement is constituted by valid offer under section 2a, valid acceptance under section 2b. It is supported by lawful consideration under section 2d. It is entered into by the parties or competent parties under section 11 majors, 12 sound mind, and if both parties have given their consent wholeheartedly, freely, out of free mind under section 14. If the agreement is not void, that is smuggling business, drug business under section 23, that is 23, and it is not opposed to public policy, that smuggling business, gambling business, casino business, lottery business, like that. 25, 26 agreement in restraint of marriage, agreement in restraint of legal procedures, agreement in restraint of trade, agreement in restraint of marriage, like that. Various things opposed to public policy under section 25 to 30. That agreement becomes valid agreement and is enforceable. Enforceable means if one party fails to perform the party agreement, one party of the agreement fails to perform, the other party can go to a court and get the agreement performed. That is specific performance. This is what is called. That is why a valid agreement which is enforceable become contract. According to section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. Similarly, that agreement will be enforceable provided that agreement contains or constitutes the ingredients or valid conditions, essential conditions under section 10, namely valid offer acceptance, valid acceptance, lawful consideration, capacity, capacity major, section 11, unsoundness of mind, soundness of mind, section 12, lawful not agreement not declared void, 6, legality of object, 7. So these 7 points are there. These second conscience are present in an agreement, that is what is called contract. That valid agreement becomes a contract. You know, dear friends, rainbow, it constitutes 7 colors, Vibjayar, like that. This section treats section 10 like a ball, agreement like a ball. So that ball comprises of 6 points, 7 points, valid offer, valid acceptance, consideration, like this. This Vibjayar, like rainbow, that agreement constitutes these 7 elements. It is said to be a valid agreement and it becomes a valid contract, is what I would like to tell you. So that is why chapter 2 containing section 10 to 30 lay down various provisions relating to contract, that is valid contract, void contract, and void agreement and enforceable. So in this, I want to tell you 5 kinds of contracts. The contract or agreements are 5 kinds. Instead of telling you 5 kinds of agreement, contract, you let us say 5 kinds of agreements. 5 kinds of agreement. One is, if the agreement enforceable by law, it contains all conditions of section 10, that contract, that the agreement is called contract or valid contract. In that agreement, any essential condition like valid offer absent, void, AB 2B fails, void, 2D fails, void, but agreement not declared void, that fails, it is void. Opposite to public policy, it is void. But under section 10, free consent. If free consent fails, it is voidable. If free consent fails, that agreement is voidable. Free consent fails in the sense, according to section 13, when two parties agree to the same thing in the same sense, the parties are said to have been consented under section 30. When two parties come together, they are agreed to do something. The parties are said to have been consented. A want to give his house rent for 10,000 per month. B agrees to do it because B is manager, bank manager. A is landlord. A gave his flat to B, his manager rent for 10,000 rupees. But actually, the rent of the flat is 20,000. If 10,000, if it is not given to 10,000, the bank manager will harass him. He will stop his increment. He will put him trouble. That is why, out of undue influence, A unwillingly, without any wholeheartedly give consent. So that consent is not valid. It is voidable. It is voidable. Like that, if any consent is given out of flaw in consent, like coercion, if you don't, a girl tells man, if you don't marry me, I will kill. I will kill. I will die. I will commit suicide, or I will kill. I will kill you. I don't allow any girl to marry you. I will kill, or I commit suicide. So that out of fear he marries, that is voidable. Secondly, misrepresentation. Innocently telling wrong statement, that is misrepresentation. Knowingly telling wrong statement. So when you go to shop, you want a good TV, that Samsung, LG are good, Onida or prestigious companies TVs he will give. The shop owner doesn't know, but when the TV is taken, within 1 month, the TV is lost. That is misrepresentation. Shop owner doesn't know the defects in it. When the defective TV is returned, the shop owner got it repaired and managed it, polished it, and give it to some other purchaser who asked good TV. It is a fraud. It is fraud. It is fraud. Deliberately, knowingly, shop owner knows that it is defective TV, but he tells that it is a good TV and sells it. It is called fraudulent misrepresentation or fraud. Like that, coercion, misrepresentation, fraud, undue influence, fact or mistake of fact, mistake of law, basing on if any flaw is outcome of that consent is not a free consent, the aggrieved party who is subjected to loss can repudiate the contract or avoid the contract. That contract is called voidable contract. That is why, dear friends, please note that agreements are three categories. Valid agreement, that is, valid agreement means which is constituted by 2A, 2B coupled with conditions of section 10 is valid agreement. That valid agreement is called contract. Second one, if the agreement lags behind free consent under section 14 to 20 of the Contract Act, that is called voidable agreement. Voidable agreement. Voidable agreement may be valid or invalid. Suppose a man who wants to get married to a girl. He went to some house for seeing the girl. So that family has two daughters, elder daughter and younger daughter. They showed younger daughter at the time of they showed younger daughter to get him married, but the younger daughter was hidden later, and the elder daughter was the boy got married with the elder daughter. During marriage performance, some as per their customary practice, some faces are closed with flowers and all. The boy could not identify and tied the knot. And when the following day the girl is presented before him in a nuptial room, he opened the flowers and saw and found different. Then he comes out of the nuptial room and cries on the parents of the girl. What is this nonsense? What you have done? You showed me one girl and got me married to another girl. The parents of the girl come and rescue him, convince him, dear son-in-law, please note that my elder son is a wonderful girl. She will be a wonderful housewife to you, but my younger girl is not that much good. She has a lot of ego. She is mischievous. You will be more happy if the boy keeps quiet and continue accepts her as wife. That agreement is valid agreement. If he says that, valid agreement and becomes a marriage contract. If he says that no, I don't want all these cock and bull stories. I want a beautiful girl only. I want to cancel this marriage. If he says that, it is a voidable agreement. Void, it will become void agreement. He can repudiate the marriage, then the agreement becomes void, and the boy and girl will get separated. So this is what is called voidable. Valid, void, voidable. Then in addition to that, there are true agreements. There are two agreements. One is unenforceable agreement and illegal agreement. Unenforceable agreements means certain agreements require some technical formalities or legal formalities. Suppose you are in possession of a house. If you don't have title deeds, you cannot sell that house. You cannot bring loan on that house. So that is your house without documents is document without any title deeds. If you enter into any agreement, that agreement is unenforceable agreement. Similarly, if you have two-wheeler or four-wheeler in your possession, you do not have the registration or title deeds of that vehicle, two-wheeler or four-wheeler, you will not be able to sell it. So that is if you enter into an agreement, that agreement is called unenforceable agreement. Finally, illegal agreement. What do you mean by illegal agreement? Agreement, an agreement to do an illegal act, or an agreement by two or more parties to do a legal act by illegal means, that is illegal agreement. An agreement to enter into an agreement which is not illegal, an agreement to enter into an illegal act, or an agreement which is not illegal. In a simple word, two or more parties enter into an agreement to do some illegal act or legal act by illegal means. Legal act by illegal means. What is legal act? Illegal act. Suppose I will give you 5 lakhs, you go and kill that person. That is agreement to criminal conspiracy. So I will give you this much money. You will go and spoil their house. That is another thing. That is illegal agreement. Illegal agreement. So if agreement is entered into commit an offence under Indian Penal Code, that is illegal agreement. It may be speaking lie, theft, robbery, kidnap, abduction, whatever it may be. It is so entering into agreement to do a legal act by illegal means, that is also illegal agreement. For example, a parent tells somebody in entrance examination, so I will give you the medical seat 1 crore, management quota 1 crore, for example. This man will tell somebody in entrance examination area like this, I will give you 50 lakhs, you please see that my boy will get some admission with some manipulated rank. So they take 50 lakhs and manipulate the rank and get the boy or girl admitted. So admitting the child in medical course is legal, but it is committed in illegal means. So that is also called conspiracy or criminal conspiracy or illegal act. These are the 5 kinds of agreements I have told you. That is second chapter. Third chapter speaks about contingent contract. Section 31 to 36 deal with contingent contracts. Contingent contract. Section 25 to 30 deal with contracts opposite to public policy, activities opposite to public policy. But Section 31 to 36 deal with contingent contracts. This is a section wise classification I am telling you. What are contingent contracts? Contingent contract is a contract that is done under some peculiar or special circumstances. For example, a middle class man is there. His salary is 50,000. His house rent, all provisions and all are general expenses. House rent some 10,000 rupees, provisions some 10,000 rupees, like this, like this. There are normal house rent, children bus fare, provisions, milk, all these things are general expenses. Suppose this month, girl some function takes place. So girl marriage, daughter marriage, that is contingent expenses. Suppose this month some group, some good number of guests come to the house for some purpose, that is contingency. Some Ayyappa Swami bhajana karikram or some other temple karikram, some other spiritual karikram is organized. That is contingency. Okay. Giving city bus fare to pocket money every day to child is a normal expenditure. In that particular month, you purchase the scooty to your child, that is contingent. Contingent means something happens. It may happen or may not happen. When it happens, we don't know. If any contract is entered into for that purpose, it is a contingent contract. Suppose there is a casino houses in some foreign countries, it is a gambling. That is some horse races, lotteries, they are all contingent contracts. So here they are contingent contracts. So coming to the next topic, section in this contract of wagering and wagering contracts are valid, contingent contracts are not valid. These aspects you study under section 31 to 36, third chapter. Fourth chapter contains section 37 to 68, that is performance of contracts. What do you mean by performance of the contract? Both parties acted in accordance with the performance of the contract. When a contract is created, when an agreement is created, some contractual obligations are created on both the sides. If both the parties fulfill their contractual obligation, the contract is said to be performed. Okay. In Contract Act, in chapter wise, first chapter contract meaning, definition, elements and kinds. Second chapter first element offer and acceptance. Third chapter say next element consideration. Next chapter next element free consent. Next chapter next element capacity, section 11 and 12. Next chapter next element legality of object, a lawful object, section 20. Legality of object, section 25 to 30. Next chapter performance of contract. If contract is fulfilled by both the parties, we say that the contract is said to be performed. If one party, either this party or that party, fails to perform his contractual obligation, that is called non-observance of contractual obligation or failure to perform the contractual obligation, then we say that it is called breach of contract. Every contract, every agreement that is and every contract that is entered into will have to be closed, will have to be completed, will have to be extinguished or will come to an end. Yat bhavati tat nasyati. Everything that is created in this universe will be destroyed one day or other. When student joins 3 year law course in first year, the contract is entered into. When he leaves the college after a successful completion of a third year, it is called performance. If 3 year law course is successfully performed, it is called performance. If he discontinue the college middle, if he fails some subjects and go leave the college without degree, it is called breach of contract or failure to perform the contract. So like this, every contract, when A wants to sell the house, B wants to purchase the house, A pays complete makes payment 100%, and A gives the delivers the house and B makes payment, we say that the contract is performed. If A doesn't sell the house in the middle, or B doesn't pay the money in middle, it is called breach of contract, failure to perform the contract. There are so many concepts under performance, there are so many concepts under the discharge, under various sections. I have explained performance of contract, various aspects, novation, frustration and all, and discharge of contract also I have done. So that is the thing. So for these section chapter 4 containing 30 section 37 to 67 of the Indian Contract Act deal with chapter 6 chapter 4 chapter 4 containing section 36 to 67 of the Contract Act deals with performance of the contract. Next one, chapter 5. Chapter 5. Chapter 5, leave it chapter 5. Chapter 6, of consequences of the breach of contract. If contract is performed, it is called performance of contract. In that we study frustration, novation, reciprocal promises, joint promises, and all these things we study. These things I explained in detail topic wise in my previous lectures. And the next one is, if contract is not performed, it is called breach of contract or failure to perform the contract. Breach of contract or failure to perform the contract. Section 73 to 75. So when once one party fails to perform the contract, the other party will go to some remedy. That remedy may be specific performance, and he wants that the contract is to be performed by that party. A did not sell the house. He prays God that A should sell the house. Otherwise, B goes to court. B did not purchase the house. He should purchase and pay money. That is specific performance if A goes to court. That is what is called specific performance, or payment of compensation by means of damages. There are various kinds of damages, liquidated damages, unliquidated damages, what is damage, what is damages, what are various kinds of damages. All these things I explained in detail. All these things I explained in detail. Now, last chapter, that is actually fifth chapter is fourth chapter is performance, sixth chapter deals with consequences of breach of contract. But in the fifth chapter actually should come last. That is section 68 to 72. It is called of those agreements. So there are of those agreements resembling the contract. So this girl is looking like Aishwarya Rai. This boy is looking like Amitabh Bachchan. This boy is looking like Allu Arjun. Like this. That is what is called resemblance. So this transaction is not a contract or agreement, but it looks like a contract. What a contract will have, what an agreement will have obligations, contractual obligation. Even though there is no agreement at all in writing, this activity also contains some rights and obligations. So The quasi contract is that contract which resembles the contract. In a contract, there is a written agreement entered into or oral agreement entered into. But in quasi contract, no agreement is entered into. It is out of air. It is out of principle of natural justice. The principle is no one shall enrich any benefit at the expense of other. No one shall enrich any benefit at the expense of other. That is, suppose section 60, chapter 5, containing section 68 to 72 of the Indian Contract Act deals with five kinds of quasi contracts. There are some agreements. They are not agreements in reality, but they look like agreements. They resemble the agreement. They are necessities applied to minor, section 68, like that. Finder of lost goods, payment made by mistake, like this. For example, tell you section 68. If any minor is not qualified to enter into contract, but suppose minor is taken into contract for expecting some benefit. If there is a profit, minor will enjoy the profit. If there is a loss, minor is not answerable. If there is any liability of minor, the minor is not responsible. So, in normally, if for any contract, minor is put to liability when a person enters into contract with minor. A minor is liable to pay something that other person cannot file a case against the minor because minor is not answerable or accountable. But if some out of the principles of natural justice, divine law, some necessities, basic needs, food, clothing, shelter, medical aid, education expenses, like that, some amount is paid to minor. If the minor escapes the liability, the law will not allow him. The minor has to pay that money. That is principle of natural justice. There is no any agreement. So that is next, finder of lost good. Suppose we know, dear friends, we are taking transactions on phone pay. Our banker gives credit to one account instead of another account. So my banker gave a credit to my account some 1 lakh instead of some other. So having seen the account balance, I used that money immediately. Immediately they know, they get immediate corresponding debit and take it back, no problem. Suppose the banker did not trace out the defect, mistake, and kept quiet, and I don't know, some people don't know what is the balance in their account. Transactions, checks come and go, so they don't know what is that. By mistake, that gentleman has withdrawn money, seeing that he has balance in that account. Subsequently, banker informs, sir, yesterday by mistake we credited 1 lakh to you, but unexpectedly, unfortunately, you have withdrawn that amount. You have to credit that money. You have to put money in bank so that we can take it back. The banker will say. Then back, no, why? My balance, my account contained balance, I used it. I did not steal from you. I'm not responsible. Is what you cannot say. If the customer says like that, I have no obligation to return the money credited by mistake. That banker can give complaint to police. Police will come and action will be taken. Not only criminal action, but also you have to pay, return the money with interest if any. So this is what like that, finder of lost goods. Suppose in one movie, one cake is delivered to one house. If suppose we are in a dole delivery, any material is delivered to one house instead of another house. The wrong house which received the parcel enjoyed it. If the delivery man comes again and demand, you have an obligation to give it. In this particular case, these are the principles of natural justice. Though there is no court, no agreement in writing, oral or in writing, by air those agreements are there. Though you cannot say that, so you gave me, we ate that cake, but you have to give money if you are not entitled to receive it. This is the these are the this is what is called chapterization discussion. Now I will give you some brief outline of. So dear friends, I told you here the time is 1 hour 44 minutes. So in this is the case, and in next class I will give you contents wise chapterization. Actually, as a matter of fact, I wanted to give everything in 3 to 4 hours, but it will be too long, so that I am stopping here, and I will give you this. I will take the textbook, I will take the chapter. What is this? What is this? What is this? What is this? I tell you. What is consideration? What is contract? What is cross offer? What is Carlyle case? Like this, all contents I will explain straight away in the next class. Please watch this and make note of it. Second lecture I will give, but instead of general subject as a whole, I tell you topic wise, contents wise, I will tell another. Accordingly, I did in Telugu lecture also. For Telugu lecture, I did not cover elaborately because I have taken lot of time for introduction only. So I don't take any time for introduction. I will take chapter 1 to chapter last. Whatever topics I have covered now, I leave it and I proceed to. Because our frustration of object, novation, novation, Clayton's rules, all the topics, agreement in restraint of trade, all these things I will explain in brief. All the topics are I explained in Telugu and English long back, but all the one topic one chapter was explained in one lecture there, but all the chapters I explain in only one lecture. The contents according to textbook I will explain in the next class. Thank you very much for your patient hearing. God bless you. Please note that every 1 week one subject will come. Like that, I am trying my level best to cover all the 30 subjects. Whatever topics or subjects I did not cover, I will take up, and the second part of this lecture I will take up in next class, and contents as per contents, first chapter to last chapter I will tell you. And dear friends, please follow English lecture, Telugu lecture will have lot of difference. So whatever was not covered, it will be covered in English. Whatever covered in Telugu may not be covered here. Some topics were covered in Telugu language part 2, but are not covered here. So like this, I suggest you, the students of Telugu states, to follow Telugu and English. Please note that Rega Surya Rao lectures are very lengthy. Today you find lengthy, but in examination you find these lectures very shorter, because those, even the students who are not very sincere and showed responsibility in classwork and attending classes, were constrained to attend my classes 3 to 5 hours also. Even very when every evening in all examinations I conducted exams, I conducted the classes to my hundreds of students every day. But next day morning, VIPs were coming, income tax officers, police officers, and other government officials used to come to me. With this, all these experience only, dear friend, don't, if anybody makes adverse comment, keep it, set it aside, because normally it is very difficult for any teacher to have such an experience. What I have, what I have. We, of course, there may be number of teachers who will be able to teach excellently, 100 times better than me, 1,000 times better than me, but I don't find there whether there may be any teacher possessing such vast experience in all field, and such teacher who has written books on all subjects, who has taught on all subjects. And my type way of experience, normally any teacher, even in national law schools or prestigious law schools also, is not expected to have trust my lectures, trust my service, come up in life, but don't make. I also suggest my teachers, my friends, my teachers who appointed as lecturers in any law school. I suggest you watch my summary lecture, then topic wise lecture, then you take any textbook of your choice. You will flourish as a good teacher, and you work hard and see that no student should rely on Raga Suryaro lecture, and you make that, you see that your student should rely on your lectures only, and then that is my suggestion to you. So for newly appointed, my beloved guru Professor K.S.N. Murthy, who late K.S.N. Murthy sir, who after retirement as Professor of Anantapur Law University, SK University, Sri Krishnadevara University, Andhra Pradesh, India, he joined as the principal of Nyaya Vidya Parishat Law College, Visakhapatnam. When he was telling, he was used to tell his newly appointed law lecturers, you read Raga Surya Rao book first and then read any book of your choice, you will succeed as lecturers. So I have taken it as a defense that great teacher, Professor K.S.N. Murthy, suggested my book to teachers to read first Raga Surya Rao book and then read any textbook of your choice, and flourish as a teacher. Thank you very much for your patient hearing. So if I teach topic wise with fresh energy, you will be able to receive effectively in another lecture. Next lecture, contracts one, topic wise, contents wise, I will take up, and after that I will open constitutional law. Constitutional law cream as a whole I give you, and topic wise I will give as a whole. So this is if you read two lectures, if it is the possibility is there, I will give whole lecture. So after this is the position. I don't like to give beyond this. Thank you very much for your patient hearing, dear friend.